Welcome to Fairly Competing, the show providing in-depth analysis of trade secret law and the law of non-competes and other restrictive covenants. Whether you're a business owner, CEO, in-house counsel, HR executive, or other employee, or a new lawyer or advanced practitioner, join us for a discussion on the latest trends and hot topics, evolving federal and state laws, key developments, and other emerging issues in trade secrets, non-competes, and employee mobility in today's knowledge economy. And now, here are your co-hosts, John Marsh, Ben Fink, and Russell Beck.
Thank you, Erica. Here in Boston, Russell Beck.
Here in Atlanta, Ben Fink.
And here in Columbus, John Marsh. Well, I'll take it from here. Today's topic is one I think that's really, really interesting. And we're going to talk about litigation funding. For those that have been following developments within the trade secret sphere, you've probably noticed that increasingly litigation funding has become a hot issue and a hot topic. I think it's been used in the patent sphere for some period of time, and there's increasingly a developed set of rules that are governed disclosures in patent cases, and there's some recent authority that we're going to talk about as well. But it's relatively new to the trade secret sphere, primarily because trade secret cases are increasingly starting to look a lot more like patent cases, and trade secret owners are starting to pursue damages, increasingly large damages, in addition to seeking injunctive relief. So we thought one of the best ways to learn more about litigation funding and its intersection with trade secret law was to invite a colleague that we've been working with in the trade secret speaking circuit for the last 3 or 4 years. And with us today is Stephanie Southwick. Stephanie's with the Law Finance Group, and has been actively assisting trade secret owners in getting trade secret funding for a number of years. And Stephanie, thanks again for joining us here today.
Well, thanks for having me. I'm happy to be here and talking to you all.
So Stephanie, obviously you're in the litigation funding space now. Tell us how you gravitated that, because I know you were in private practice for a number of years.
I was. So I am currently at Law Finance Group. We're based in Northern California in Marin County, across the Golden Gate Bridge from San Francisco. And I've been at LFG for about a year. Before that, I was doing this kind of same work at a larger publicly traded litigation finance firm for about 4 years. Before that, I was a litigator. And I did business and actually trade secret litigation here in San Francisco and Silicon Valley. I did that for almost 16 years. And in that context, actually, I was the beneficiary of funding. It was kind of the first time I learned about it. It's probably, 8 or 9 years ago now. But I represented a client in a trade secret case, and that client, that company, had funding. So that funding was paying my fees. And I thought, this is fascinating that somebody else is paying my fees. And it's what allowed that case to continue. And then I also, as a litigator, did outside diligence counsel for a litigation finance firm in trade secret cases. So did all of that and was really interested in this world. And I actually represented a lot of investors and startups, kind of had the bug to do something more on the business side. And this just seemed like a great way to kind of transition and still use my education and experience.
So am I correct in my assumption, I guess, Stephanie, that the increase in money damages trade secret cases has really led to the greater opportunities for trade secret owners that might be interested in getting some financial assistance with these cases? Is that something that you've observed as well, or been your experience?
Yeah, I think so. I think it's the increased damages. I mean, you have to have a certain amount of damages for funding to make sense. So it doesn't always make sense in the smaller cases, even though you might have a great case on the merits. There just might not be enough room there to include a funder in the mix. So I think that's true. I also think there's more trade secret cases, and I think the whole kind of space has matured. And I think more and more companies are thinking about their trade secrets as assets, like they used to only think of their patents. I think kind of put all those things together and you're seeing more trade secret cases and more funded trade secret cases. And by the way, trade secret cases often lend themselves to funding because the trade secrets are stolen by the larger company, right? And it's the smaller company who might be the plaintiff, and they may not have the financial resources to fight the fight they're about to enter.
Yes.
Stephanie, how much is enough? You mentioned, the smaller cases may have great liability, but not enough damages for funding. Like, what's the threshold for you?
Yeah, I think standard in the industry is usually about 10x. So you're looking for damages that are 10 times the funding amount to make sure, and that's just standard, and it every case is different, right? But I'm without talking about a specific fact pattern in a case, I'm just throwing this out there. But you want to make sure there's enough room for the funder to get the return, for the attorneys to get any type of contingent fee or partial contingent fee, and then still for the company or the plaintiff to get about at least 50% of the recovery. Because if the plaintiff's not getting at least that amount, they're not necessarily incentivized to take a settlement that might be quite reasonable, right? That why not just roll the dice and go to trial? And that's not anything anyone wants.
So are there particular types of trade secret cases that have certain qualities or certain indicia that make them more attractive to funders? And if so, what are those?
Well, like we just discussed, they have to be large enough.
Right.
I think trade secret cases in general make for good cases to fund because of the story. There's usually a story that goes along with them. Unlike maybe a patent case or a breach of contract case, the allegation at least is that there's been theft. Right. And so the story is interesting. It's interesting to a judge. It's interesting to a jury. And I think because of that, it's also very fact specific. And the plaintiff is more likely to make it to trial because they're probably going to survive, not always, summary judgment, right? Because there's going to be some factual disputes. I also think that trade secret cases are often very important. They're often bet the company types of litigation, and they usually get the defendant's management's attention earlier than, say, a patent case. There's so many patent cases filed these days that a larger company might have an in-house team. They get the patent complaint, they go to work on it, and they might not even really be informing the C-suite about that case. Trade secret cases get management's attention right away, usually because someone is alleged to have done something wrong. And oftentimes principals are deposed. So I think in general, trade secret cases lend themselves to funding. They also can have very large damages attached. And we'll talk about this later. This is becoming a pro and a con, but the damages are more flexible than other types of litigation because we have unjust enrichment, right? So we're not just looking at the harm to the plaintiff, like lost profits, for example. We're also looking at the benefit to the defendant, and those can lead to very large verdicts. Now, that's not always good, as we can discuss later with trends in damages and reversals with the Court of Appeals. But I do think that the ability to get a large damage award makes trade secret cases, fundable. And I also think because of that, because of the nature of unjust enrichment and the ability to base your damages on the benefit to the defendant, it can also increase the amount of cases, because sometimes those small companies, when their trade secrets are stolen, they don't have the opportunity to compete in the marketplace because their trade secrets are stolen, right? They're shut down before they even have a product. So I think it just lends itself to more litigation, especially in the tech world, and really fundable cases.
That was an incredibly helpful answer. You in fact, anticipate some things that I was going to ask. Maybe talking about the process would be helpful here. So we've got, based on the criteria you laid out for us, we have a small company that's going up against the mammoth competitor. The mammoth competitors got Williams and Connolly, or O'Melveny and Myers, got a first-rate law firm that knows what it's doing and is going to put them through their paces.
Berman Fink Van Horn, for example.
Yeah, exactly. They're yet another trade secret behemoth. But and you've got poor little Beck Reed riding there, just needs some help. And how do you? So, what's the process for someone like Russell that's up against a really well funded adversary that can make it a really tough case for them to prosecute?
Well, I think the process is understanding the case first, unless the company comes to a funder before they have litigation counsel. And that happens too. And then in that case, we would, work with the company to find the right litigation counsel. And right can mean many things, obviously, competent, excellent litigators, but also the right size budget. Yeah. Not every case can handle, a $20 million legal fee budget, right? So you're looking for the right, and it might be the jurisdiction, obviously the type of case. So we can help direct funded parties or companies to the right place. But if they already have a litigator, then the litigator or the company or both together are reaching out to the potential funders and telling them about the case. And so the first thing we would do, though, is sign a non-disclosure agreement. Because we want to protect any confidential information that's given to us. So that's kind of the first step. And then we'd have that initial call. A couple of things here. I think it's always fine to have that initial call and run things by a funder, especially me. Like I take those calls all the time and I'm happy to talk to anyone. Past that, there is some preparation that needs to be done before you work with a funder. And I say this to folks all the time, because timing is important. Sometimes if you have a potential case or a potential investment that drags on too long, it loses momentum and it becomes less fundable. So the lawyers usually need to do some preparation and then give that information to the funders under the NDA. And by preparation, I mean, obviously the merits of a case. That's what every lawyer, brings to us, because that's what lawyers do, right? You look at the merits of the case and you're going to be looking at all the merits of the case, the elements and the damages, et cetera. But you also need to have your economics prepared. And by that, I mean, you need to know what the legal budget is, the fee budget and the cost. And I know that's hard because you don't know what the other side's going to do. You don't know how long the judge is going to take. And a range is fine, but go through the exercise of figuring out what the litigation is going to look like. I would suggest through post-trial motions, and then give a range for each kind of part of the litigation. So sometimes it's going to be on the lower end if things go smoothly and the judge decides quickly, or the other side doesn't bring a million motions to compel or fight you on discovery every way. But sometimes it's going to be more expensive. So a range is fine, and we all understand it. We've been there. Funders understand the range, but you need to come with your kind of economic terms prepared too. So the funding amount is really going to be teed off that budget. So bring that budget for fees and costs. Now, part of that is you're going to want to know, can the company pay any of these costs, or is the company asking for 100% of the cost to be funded? So that's another question that, the company is going to have to figure out in advance. And the other thing that a funder is going to ask is, what type of risk is the law firm willing to be on? Is the law firm willing to defer some of their hourly rate in exchange for some partial contingent fee or success fee, whatever you want to call it? So that is important, because the funder is going to want to know, am I funding 100% of the fees and costs, which is really hard to do in the US, by the way. Usually a funder is going to want the law firm to be on some kind of risk, meaning defer some percentage of their fees in exchange for a partial upside or contingency. So you want to know what that might look like, what the firm's willing to do, what the company is willing to do. And then damages is the other component of the economic terms, because the funder is going to be looking back to our earlier conversation, looking at that ratio of legal costs, fees and costs, in comparison to damages, to see if this case works for funding. So really, that's what you need to do, kind of prepare all of that. And that's what the funder is going to want to know in their initial diligence period. under the NDA, the merits of the case, facts and law, and then also these economic terms that we just discussed.
So it sounds like that's relatively early in the dispute, probably post-complaint. You've got a sense of where the case is going to go, maybe early in discovery. You probably prepared a budget for the client if the client and the lawyer are aligned on that. But probably before you've engaged an expert that can really speak to what the damages theories might be. Is that typical the way I've described, or is it generally the funding a little later in the litigation?
I'm not quite sure there's a typical.
Okay.
It depends, right? Because there are some cases where the client starts out paying the full hourly rate and thinks they have a war chest to get them through trial. And guess what? It's just like your house renovation, right? It always takes longer and costs more than you think. Always, always, right? And so it may be at any point in the litigation that the company says, I need funding. I can't afford to do this anymore. Now, it might be a small company. At the very beginning, they say the only way I can bring this case and the only way this law firm who I want to represent me can do it is if we get funding. So in that case, John, you're right. It may be early in the game before you have an expert. It may be later. And also, I should know that at least LFG also does judgment monetizations, meaning you have a judgment on appeal. So, or a verdict that is going through post-trial motions and then will be probably appealed. So that's really at every stage of the game.
Yeah, Stephanie, if I could jump in on that, because you and I talked about that, I think it was earlier this year or late last year. Maybe you could talk a little bit about that, especially in this world where we're seeing some very large jury verdicts, but then we're seeing a lot of them, including the one you and I talked about, get set aside based on various legal issues identified by the judge. Like, one, how prevalent is the verdict funding or verdict insurance? And then two, how do you go about underwriting something like that or making a decision as to whether to fund it when it requires basically going through the entire trial record to figure out, well, are there problems here that this is going to get set aside or going to get reversed on appeal?
That is a very big question, Ben. I will do my best, but jump in if I forget to answer parts of that. Okay, that's right. We've seen some really large verdicts in the trade secret space. And we've also seen either the trial judge, the trial court, or the Court of Appeals reverse these verdicts. I would say that it's almost become a trend in that we see more Court of Appeals reversing or lowering trade secret verdicts. And we've seen more trial court judges lately reducing either damages or the number of trade secrets or throwing out the case entirely or any combination thereof. So I think that's a trend we're seeing. I don't know exactly why, but I do think that in general, trial courts don't want massive judgments from their courtroom going up to the Court of Appeals because I think Court of Appeals are skeptical of windfalls for the plaintiff, and we have those unjust enrichment damages that aren't always tied to the harm to the plaintiff. Look, I don't know exactly why. There could be many reasons, but I definitely see a trend here. So how does that impact funding? I think, Ben, is the heart of your question. I think one case doesn't really impact funding. It definitely impacts how we diligence a case, and I'll talk about that in a second. But the other way it's really impacted funding, which you might not guess, is that there is this other insurance product called judgment preservation insurance that, I don't know, became very popular 5 years ago. I'm probably getting these, times a little wrong, but approximately that. Now, insurance companies have backed away, I think, from JPI, they call it, because of some of these reversals. It has become harder and more expensive to get JPI. If you are a plaintiff and you have a verdict, and it can be a trade secret verdict, it can be a patent verdict or judgment, or even commercial. But I'd say probably patent and trade secret have seen the most reversals lately. So because JPI is harder to get and more expensive, And for example, you used to be able to insure maybe 80% of your judgment, and now it's looking more like 50%. And the insurance premium used to be more like 10% of what you were insuring. And now it's maybe high teens or even 20, or there's different types of premiums that I'm not in the insurance industry, so I won't get into now. But because of that, we have seen more demand for judgment monetization, which is what a funder would do. So instead of insuring your judgment, the plaintiff has a judgment in hand, and we're able to monetize it, meaning give the plaintiff probably up to 25% of that judgment right away when the deal closes. And the funder is sharing the risk that the case will be overturned or remanded for retrial, et cetera. But that money is, and the investment is non-recourse. So it doesn't matter what happens, the plaintiff gets to keep that money. Now, I also think that this trend we've talked about in damages and large verdicts, Court of Appeals and trial courts kind of reducing those verdicts, judgments, or overturning them altogether has led to kind of a difference in how we diligence cases. And it's true, if it is a verdict or a judgment, you do have this huge record in front of you, as Ben noted. But that's almost easier. In a way, it's a lot easier than someone coming to us pre-filing and saying, I don't know what the defendant's going to say. We don't know because the defendant hasn't spoken yet. The defendant doesn't even know that they're about to get sued. So I think there's pros and there's cons to that. I mean, we're certainly interested if it's still before the trial court, like if it's post-verdict, but pre-judgment, meaning you still have to go through the post-trial motions. We want to know who that judge is and what have they been doing. Obviously, we're curious about the circuit. So how we diligence the case might be different. And I will say this, really large verdicts are not a pro for litigation funding. I mean, they have to be big enough to make sense and to be fundable, as we discussed earlier. But if you have $1 billion verdict, that's not good for us, right? That's going to get someone's attention, either the trial court or the Court of Appeals or both. So it has changed things, but I think there are plenty of fundable trade secret cases out there. We'll just look at them a bit differently.
Well, that actually leads me to a question, though, just in terms of the magnitude of the awards, right? And you have everybody looking at these multiple hundreds of millions or literally $1 billion plus awards without taking into account then the result when you go up on appeal or some reversal after the verdict. But how does settlement play into this? If a funder decides this would be a good time to settle the case, and we think that we're tired of spending, money on this, and we think we can get a really good settlement at this point, but the plaintiff, who is not spending the money, or at least not spending as much of the money, decides, I really want to, I want to go all in and get my hundreds of millions of dollars and my $1 billion award. How does that work? What's the process for trying to resolve that conflict?
So I can only speak for myself and LFG, and other places I've worked, but funders don't have control. So we might be able to call the company, the plaintiff, the funded party, and say, hey, we think that's a really reasonable settlement offer, and this is why. Or call the lawyer and say, that sounds great. Like, tell me why that's not good. But at the end of the day, if the plaintiff decides to go to trial, there's nothing we can do about it. In advance, we can look at who our counterparty is and make sure that we trust the litigators and make sure that we trust the company and that, who we're funding. That's really important. And we can make sure we think, and things can change, but we think that that company plaintiff is going to make rational, logical settlement decisions.
Right.
And economic decisions, because if it's too personal, like that's all out the door. We're not able to diligence what a settlement might mean when it's a really personal case. So we try our best to work with rational, logical parties that are going to make economic decisions. And beyond that, there's not much else we can do.
Is there ever anything in the funding arrangements that contemplates if a settlement at X dollars comes in, the parties agree that we'll take that?
I mean, again, I can't speak for other funders, certainly not in mine, not in LFG's. You can structure the investment to align incentives, meaning to accept a reasonable settlement offer. So, for example, there may be milestones in the funding amount that the return to the funder increases over time. The return to the funder might increase when voir dire starts, meaning you are incentivizing the plaintiff to accept a reasonable pretrial settlement because trial is risky, as you all know, so you can structure the deal to make it more attractive to the plaintiff to accept that reasonable settlement offer. But I have not ever had a case where I felt like it was appropriate or ethical to put a certain settlement amount threshold in the contract.
Right. But your approach of aligning the interests, I think that is a way to really address this issue in advance and head off any problems down the road.
Yeah, I was going to add, Russell's question is an excellent one because it does highlight what you talked about at the very beginning, Stephanie, when you're doing your homework on the lawyers, on the party, and you're structuring things to make sure that you're aligned. All right, lawyer, do you really believe that much in this case? And are you willing to take either a haircut or a kicker or a structure down the line? It gives you a chance to really get a feeling for the other partners, for lack of a better way of describing that you're aligning yourselves with early and make sure they are rational actors.
Absolutely. I mean, when we see firms that regularly work on contingent fees coming to us and wanting almost all their fees, that's a red flag. Now, I will say there are firms out there that are not structured to be able to take on a lot of contingent fee cases. And we look at that. What does this firm usually do? And when they say, we'll defer 30% of our fees, so you're paying 70%, but really that is a huge discount for us. Is that true? And sometimes it is. I mean, it really depends on the business model of the firm, and we take that into account.
Have you seen insurance coming up at this point? I know trade secret insurance there's been a lot of discussion about it. I'm not sure how much of it actually exists, but have you seen any impacts of that?
I have also heard about it, and it's fascinating to me. I haven't seen it in a funded case.
Yeah.
Yet.
It's no surprise. I mean, I haven't seen much. I haven't seen any trade secret insurance in any case that I've been involved with. Ben, you look skeptical. Are you disagreeing with that?
No, I've not seen it I've not seen anybody who has purchased that insurance, and I've not had any clients that have had that insurance who've had trade secret theft occur.
Well, I know that in the insurance context, there were reports that Appian got a pretty significant policy after the judgment. And I can't remember of the $2 billion, I think they were covered up to $600 million. At least I saw media reports to that effect. Does that sound right to you, Stephanie?
I was going to say 500.
500, okay.
But around that, yeah. Right. And I don't have any personal knowledge. I'm reading the same articles you are, John.
Correct. Yeah. I can't say that I studied the article. I looked at it in passing. Well, I've got another question, Stephanie. You've mentioned the fact that there's obviously others that are providing funding. You've got competitors for what you do. And I would presume that in some instances, companies or their law firms are shopping the case around, for a lack of a better way of putting it. How should a company or the law firm compare the term sheets, if you will, or proposals from the different funders? What should they be looking for? What are things that you think they should be aware of?
Well, first of all, I think a company and a law firm should trust the funder. I think it's really important because as a former litigator, and I know I'm talking to a bunch of litigators, who knows what's going to happen? It's litigation. That's the whole point. You don't know what the other side is going to do. You don't know exactly what a judge is going to do. Who knows what a jury might do? But what I mean is there's going to be unexpected circumstances along the way. And you need a business partner who you can work with and handle and resolve, potential complications. So I think trust is really important. This is the advice I always give. If there are economic terms that look better maybe pricing is lower or whatever it might be. Maybe you get cut in the waterfall sooner. We can talk about this in detail. But if there's something that a company or a law firm likes better, but they trust the other funder more, they should bring it back to them. They should, don't disclose what one funder's term sheet says. But if there's something that the company or the law firm likes, they should go back to the funder and say, can you do this? And I say that because there are so many ways that we structure these deals. You'll hear funders say it's bespoke. I try not to use that word, but it's true that every deal is different. And when you don't really know what a company is looking for, it's hard to put something together. We do our best, but once a company or a firm has had a chance to look at different term sheets, then go back to the trusted funder and say, this is what I like. Can you do that? And maybe they can't, and you have to move on, but maybe they can. So trust is first. I think you're also looking at the amount the funder is willing to give you. And some funders won't fund the full amount that's asked for. They might push back on a budget. It just depends. You're looking at the funder's return. How is that structured? And it can be structured in many ways. It can be a multiple of what the funder puts into the case. It can be a multiple of, I've never done this, thank goodness, but a multiple of what the funder commits. So if the funder says, I commit to $3 million in this case, but they've only deployed or put in $1 million and the case settles early, the return is still due on that full $3 million that was committed. So I think that's important for firms and funded parties to watch out for. So you really kind of want that multiple on the deployed amount, not committed amount. It can be a percentage of the recovery, although that's less likely for lots of reasons. It can be a multiple plus a percentage, or it can be a rate, just a straight rate. And there's pros and cons of all of them, but there might be milestones, for example. Different funders might have different milestones. I will tell you, in a trade secret case I had a relatively odd milestone where at the beginning I really liked the case, but I wasn't sure that the plaintiff could come up with evidence of defendant's use of the trade secrets. We all knew they stole them and they were using them, but could they prove it? And as you all know, that's what you have to do. So I didn't know if they could or not. So we put a milestone. We said, we're going to give you X amount of funding until discovery comes in. And at that point, if there's sufficient evidence of use, the defendant's use of the trade secrets, then we'll give you the rest. Now, as I'm sure you're thinking, well, the discovery that comes in is probably, a lot of it is attorney's eyes only. So we couldn't see it. So we had to trust the attorneys when they couldn't tell us what they found, but they could say, we think it's sufficient or insufficient. And we had to trust them enough to say, okay, we've overcome that milestone. So different funders might have different milestones. And then finally, I think you're looking at the waterfall, meaning how the money that flows back in from the litigation goes out. The first money is usually going to be to the funder, at least for how much they put in or their deployed amount plus some multiple. The next level might be the funders getting the rest of their returns and the lawyers getting their deferred fees or their partial contingent fee. And then the third would definitely, all the rest would go to the company. Now it can vary quite a bit depending on what the deal actually looks like, but that's kind of a typical waterfall. So those are all things you're comparing, and it can be confusing. It can be hard for the lawyers, but I do think, back to my original point, if there's something that a funded party really likes, but a funder that hasn't offered that, who they really like, they should go to them and say, can you do this? Is that possible?
Stephanie, I want to pick up on something you just said about trusting the lawyers and, their assessment of use, for example, and what the evidence shows of use. Ethical alarm bells go off for me with that, right? My obligation is to the client, and it's in the client's best interest to get more funding for the case. Yet I need to be truthful and have you trust me when I say, well, Stephanie, we got all this stuff in discovery. and there is some evidence that the defendant used it for X, Y, and Z, can I ultimately connect that up and show causation to the damages that have been caused, et cetera? I don't know. I think we can. I think there's enough right now. Like, how does that conversation go? And what kind of assurances are you looking for from the lawyer to give you the comfort level that you're going to continue with the funding when you know that their ethical obligation is to the client to try to, maximize their ability to pursue the claim?
That is a great question. In this particular case, there was a little bit more to it. Without getting too much in the weeds, there was a situation where we had an outside consultant who is also retained by the plaintiff, was able to look at the documents and was disclosed in the protective order, and then talked to us again, couldn't disclose what was in the AEO documents, but could tell us, I think it's enough, right? And so that was one way we kind of backed up the attorney's position. But the other way, Ben, is that we try to align interests. So in this particular case, the lawyers also had an out, and they said, we are doing this for 50% of our fees in exchange for a partial contingency. And if you're going to lose because we can't prove use, then we want out too. And they wrote that into their fee arrangement with the client. And so in that circumstance, we were aligned in that the law firm wouldn't want to continue and we wouldn't want to continue if they didn't think they could prove use.
So I want to pick up on that, right? So you mentioned, Stephanie, the trust, and I just want to make sure that we are clear for our audience that the trust is absolutely in both directions. The funder may be trusting the lawyer, but the lawyers also need to trust the funders. And, from that standpoint, I'm sure everybody on this call and other people listening get calls all the time from funders who are interested in talking and exploring relationships. And I will tell you, from my experience, I have one person that I'll talk to, and that's you. And I think, and it's for the very reason that we're all talking about, which is the trust and how important that is. So one of the other things that you mentioned that I thought might be really interesting to explore is the different types of funding arrangements, the terms that go into that you've identified. And you've given us a handful of those already on the discussion. But is there a resource out there for people to look at? And maybe the answer is no. But, if there is a resource, I think that kind of a thing would be very helpful for lawyers who are considering litigation funding for the first time to know, okay, these are the ways that things, these are the various terms that we might look for. Things might be more beneficial, less beneficial, and different levers to press on. Anything out there like that?
I don't know. There should be.
Yeah.
If there is, I don't know about it. I will say this, like going back to timing is important. You have to be prepared before you approach a funder. Like, I don't feel that way with my contacts. Call me and say, I have a potential case. I take these calls all the time. What do you think? And most of the time, like, it probably won't work. It's probably too small, or this or that, or it's probably not collectible, or it might not be collectible. But run it by me, and then we can talk about structuring and terms and I can try to educate people, but I don't know of a resource. And Russell, there probably is. Sorry, I just
Well, that's
don't
okay.
know.
Yeah. Well, you don't have a need for it, right? I mean, it's the people like, the others, the lawyer side of this that has a need for it, or the client side of it that would have a need.
Yeah. Well, and to your point, I will say this, that there are a lot of ways to do this, right? Because a funder can fund your clients, the company. A funder can also fund the law firm in a portfolio arrangement. So the contractual relationship is between, for example, LFG and the law firm. So that's totally different, right? And there's all sorts of different ethical concerns with both of those. And then we can also do judgment monetization. Again, that's with the company, but it's different because you already have a judgment in hand. It's a different asset, if you will. So there are a lot of different ways to do it. And I will say that sometimes we have seen a law firm representing a client who's paying by the hour, and then the client gets into the litigation. It takes longer and costs more than they thought, and they want some funding. So the company could go out and look for funding at that point. Or what we've also seen done is a law firm convert their fee arrangement to a contingent fee, and then they get funding themselves. So that's how the law firm is able to keep the lights on, if you will.
Yeah, that's
And the client doesn't. But so there's a lot of ways you can do it, but I don't know of a resource. I'm going to look into that and get back to you.
okay. And we will put it in the show notes
Great.
if we find something.
If I can find something.
Show notes such as they are.
Great.
And that kind of segues to one last issue that I was thinking about is discovery and discoverability, if you will, of communications, the funding agreement, or the existence of funding. I know that there appears to be a trend towards the identification of whether funding's taking place. In advance of our call today, I mentioned the decisions that we've been seeing out of the Delaware Federal Court, and the fact that the funder and the party being funded have got on the wrong side of the judge in that one, because the judge had some very specific requests for disclosure. But it does appear that there's at least a trend towards transparency of at least funding, maybe not the agreements, maybe not the communications with the funder. But Stephanie, in your experience, have you found that at least the communications that where there are the frank assessments of the strengths and weaknesses of the litigation, the things that you're really relying on so that you can trust that the lawyer is shooting straight with you and telling you what you need to know so you can make the right decisions? Have you experienced any cases where there's been a risk of that information being revealed, or have you generally been comfortable in maintaining privilege over those pursuant to the NDA and other things?
I've never seen those documents have to be disclosed. I've never heard of it. The identity of a funder or the existence of a funder is very different than a party's own counsel saying these are the strengths and weaknesses. As far as I know, every judge that has looked at this says what the lawyer thinks or what the funder thinks is not relevant. So it stops at relevance. You don't even have to go to privilege or work product, and NDAs, which are all these other ways we bolster this. But they say that's not relevant to the claims and defenses of the case. Who cares what the funder thinks? Now, there are exceptions when the parties have made it relevant. For example, if it's a standing dispute and the patents that are being challenged have been assigned to a funder, that's different, right? Or there's another circumstance where the class counsel's adequacy was called into question and they said, but no, we have plenty of money to make it through. We got funding. And so at that point, they've put it at issue. But for every other normal case, and especially trade secret cases, I've never seen it go that far. Now, plenty of defendants have asked, because that's what defendants do, right? They're trying to create a sideshow, and it becomes expensive and it takes time. All the things defendants want. They want the case to be longer and more expensive. And if there's anything salacious in there, get it in front of the judge. I've never seen it happen. It's very, very rare. The defendant would have to show relevancy, which except in those unique cases, I don't think they can. But we do ask parties to sign an NDA, and we never want privileged information. To your point, John, like, don't give us your attorney-client privileged information. You can talk to the funder without telling us what you've advised the client. That is, I mean, as a former lawyer, just don't do it, right? And we don't want you to do it. Keep that privileged information privileged. And so anything you give a funder would fall under the NDA, and it would be attorney work product, not attorney-client privileged communications. So I think that's really different. I'm not that worried about it. I'll tell you, I don't really see, except for these few jurisdictions, I will disagree with you, John, that there's a trend in even disclosure. Most judges don't care. They really don't, because it goes back to relevance. It's not relevant to the claims and defenses of the case. And most funders don't try to control the settlements. I think if judges cared about anything, that's what they would care the most about, that some other party is in the litigation controlling things. Most of those funding agreements, and I'm speaking for myself here, don't contain provisions that would allow the funder to control the litigation. So I think judges, for the most part, aren't trying to go there. Now, oftentimes the plaintiff or the funded party wants the other side to know that they have funding. So some of these jurisdictions where there is mandatory disclosure of the existence of funding is not so harmful, because then the defendant knows that the plaintiff, that somebody has spent a long time looking at this case and they think it's strong and they think it has merit and they've put their money behind that case, and the plaintiff has enough to fight usually the big guy on the merits. So I don't think it's terrible.
Stephanie, I think that's a great point. Unlike insurance, right, where that assessment is just a very, very different kind of assessment. It's one that's made far earlier in the process. That's a really great point, actually.
I agree.
Stephanie, that was great. This has been a fantastic conversation, very enlightening. I hope that the audience got a lot of information out of this. I know I did, and I think we all did on this conversation. And so look forward to working with you more in the future. And hopefully our guests will reach out to you as well, because I actually think, as I told you, you're the only one that I've worked with and the only one I will. So thank you very much.
This was a lot of fun talking to you all.
Thank you.
Thank you, Stephanie.
Thank you, Stephanie.
Thanks all.
That concludes today's show. You can visit the official podcast website at fairlycompeting.com. And please note that this show is provided for informational purposes only. None of your hosts is providing legal advice, and your use of this podcast does not create an attorney-client relationship in any respect. Thank you all for joining us.